On behalf of Reinhardt, I'd like to welcome all of the attendees to this webinar on director independence and other hot topics in nonprofit governance. Thank you for attending both in person and those of you on the webinar. We appreciate your being here today. We are excited about this topic and have a very nice panel of speakers today. It's a complicated topic, and we're going to try to allow as many questions as we can at the end. And some of the areas are uncharted ground, and as you'll see as you get into this topic, have to do with not necessarily case law or formal IRS pronouncements, but actually instructions to the 990 and how people are interpreting this in practice today. So we are very excited to take on this topic. I'm Tracy Klein. I'm the chair of Reinhardt's health system practice within our health department. And joining me on the podium today is Lucian Brodry, who's a shareholder in our tax area. Lucian is one of our leading attorneys in the tax-exempt area. He's also an expert in executive compensation, and he's an all-around great guy, so thanks to Lucian for being here today. And warmest of welcomes to Pam Connect from Accord. Pam is the president of Accord Inc. And I know her through her role in consulting to health systems nationally. She is almost a professional lecturer, I would say, on strategic planning and board governance for many of the largest health systems nationwide. Pam is also one, with her partner Ed Kasnick, one of the board of the advisors for the Governance Institute, which is a national sort of think tank on governance issues. So Pam is really at the forefront of a lot of these issues in practice across the country with some of the most sophisticated nonprofits in the nation. I met Pam most recently and worked with a shared client, and I will tell you it was the finest strategic planning retreat that this particular client had ever had with their board. Pam is one of these individuals that gets down into the details of what's really going on in the organization, and then leads the governance and strategic retreats from a position of the factual setting that the institution finds itself in. And for those of us who are involved with board governance, I can't tell you how important that is. You can broad brush this stuff, but ultimately it comes down to the facts, and it comes down to helping leaders of nonprofits get through complicated facts in an orderly way that respects their process and their institutions. So anyway, thank you, Pam, for being here today. We're very pleased about that. Before I start, I just want to take one moment to thank Mike Smith. Mike, for those of you at Reinhardt know, he is the chair of the Tax Exempt Board Group, and he has done a marvelous job of putting this group together as a practice group within Reinhardt. We felt a couple of years ago that we really wanted to put some laser focus on the area of tax-exempt orgs. We represent a lot of tax-exempt organizations, some in healthcare, some in real estate, some in nonprofits, and some foundations. And Mike took the lead in an area that was probably not necessarily one that anyone coveted, and he put together a cross-section of our firm to really get down and analyze tax-exempt issues from all practice disciplines. And he leads. He won't admit it. He's a humble guy, but to me he's like a servant leader. He's a very smart guy, and he's a very kind guy. So join me in a round of applause for Mike Smith. And with that, we will get started with the presentation. As I stated earlier, our presentation today is about director independence and other hot topics. If you look at page 4 of the PowerPoint, you'll see all the topics that we propose to touch on today. IRS standards for director independence, how nonprofits should analyze ongoing director independence, the lead director concept and the designation of the lead director, financial or business interests of directors and how they affect director independence, competency-based governance, succession planning, implications of independence on board committee assignments, And lastly, best practices in handling conflict of interest. So it's an aggressive agenda today, and we'll try to be very pointed and very concise for you. Before we get started, and Pam mentioned this to me, she said the biggest thing we need to do is start out with an overview of fiduciary duties, and I think that was an excellent point. I think most of you are familiar with the fiduciary duties that are owed by all directors. But let me just remind you of what those are. First, the duty of care. The board must act in good faith with care an ordinarily prudent person would exercise under similar circumstances. And let me point out that that relates to really two functions. One is the duty of care to do due diligence in the case of a specific transaction. But that also relates to what we call the duty of oversight. And if, for those of you who might remember the Caremark case, back in the 90s, directors are held accountable for the systems they put in place to ensure that the corporation operates in a legally compliant and appropriate manner. So it's not just analyzing, the board book on any given day. It's understanding that you've got the systems in place. You don't have to do all the functions, but you have to make sure there are systems in place to make sure the institution is governed appropriately. The duty of obedience is an interesting one, and that really relates to the organization's charter and their procedures and policies. It's the duty, as it says, to act obediently and to follow the charter and to follow the mission of the corporation. The case that I like to talk about is Shorter Hospital versus the Baptist Conference. Very interesting, well, not very interesting for non-lawyers, but I think it exemplifies the concept. Shorter College was sponsored wholly by the Baptist Conference. Shorter College was an independent entity. It was a secondary school. And basically, the Baptist Conference was essentially moving funds from Shorter College to use for its other missions, ministries, etc. And so the board of directors of Shorter College got the idea that being affiliated with the Baptist Conference was not good for Shorter College. And they created a new 501c3, they moved all the assets and began their own Shorter College, which was independent. And they were sued for breach of fiduciary duty. The directors who approved that transaction were sued, and the court said they actually fulfilled their duty of care because they had carefully analyzed the pros and cons and had understood exactly that it was in Shorter College's interest not to be affiliated with the Baptist Conference. But where they were held liable was under the theory of breach of duty of obedience, because their charter said, frankly, they were part of the Baptist Conference, and they were to be run in accord with that organization and its mission and purposes. So that's duty of obedience. Duty of loyalty is just as it suggests, to discharge your duties unselfishly, to make sure when you're sitting in a boardroom, you've got your corporate hat on and you are focused on what the corporation needs. And that means you should be disclosing situations where there are potential conflicts, avoiding competition with the organization, and keeping confidences. I'm going to just make a general comment by way of introduction that it is easier, in my judgment, to fulfill your fiduciary duties when you in fact are an independent director. It's not to say that you can't do it if you are independent, but it might just be slightly easier because the area of independence, especially when you think of duty of care, is your ability to provide necessary oversight. So, to the extent that you have entangling financial, and that's a concept that I think is really important, entangling financial transactions, commitments with the institution or with key officers, directors, key employees, that may impede those precise moments where you need to really reach out and say, I think we're not doing this quite right, I have a suggestion to make, I think we need to change our structure. So that's why fiduciary duties are important and have to be considered under the topic of board independence. And before I turn it to Lucian to really kick off on intermediate sanctions, I want to just quickly say nonprofit governance is an area of focus for the IRS. And proper governance practices are sort of your rules of the road. They keep you on the right pathway as an institution. For those of you in the for-profit sector, Sarbanes-Oxley, and you'll see a lot more attention on board governance for publicly traded companies. I would remind you that healthcare systems and some other nonprofits issue bonds, And those are essentially a security. So you're seeing in the aftermath of Sarbanes-Oxley and some of the Wall Street corruption scandals an intense focus on how you conduct your business as a board from a governance perspective. As I said earlier, much of the policies of the IRS on this subject, this narrow subject of director independence, are actually articulated through questions on the revised Form 990 and through instructions on how that form must be filled out. So with that, I'm going to turn it over to Lucian, and Lucian is going to tell us a bit about director independence in the tax arena.
All right, thank you, Tracy. Moving to my slides to talk about the key tax issues. The first bullet point there may be something that's a little bit surprising to some of you, and that is there is no specific section of the code or the regulations that requires an independent board. Now, so you might be asking yourself, why are we here? Well, as the law in this area has evolved over time, especially for 501c3 organizations, it's become almost a de facto requirement. I've spent a lot of time filling out and submitting applications for exemption, and I've had the IRS on several occasions come back and sort of make the organization change its board before they'll recognize exemption. I mean, even for stuff like small soccer clubs, if you have too many family members on the board, they'll come back and ask you to change it. Now, where does this concern come from? Well, it all relates to really one of the fundamental concepts of being nonprofit. And that is, for federal law to be nonprofit, it really means that private individuals can't benefit from the assets or the profit of the organization. It doesn't mean that the organization can't generate cash flow. It just means that private individuals can't take that cash home at the end of the day. So that concept is codified under the private inurement doctrine, which generally applies to almost all exempt organizations. From the IRS's perspective, and this is backed up in actually a number of court cases, independence is key to avoiding private inurement. We've had the opportunity to litigate a number of reasonable compensation cases in the for-profit area, and the courts, even in the Seventh Circuit, when they're looking at a compensation arrangement, and usually that's a shareholder employee determining whether they're paying themselves too much. If you can show in those cases that the compensation was approved by independent directors, or in that case, independent shareholders, that's a tremendous fact, and it usually will win the day. I mean, even if it might be higher than what an appraised amount says, oftentimes if you have that independent sort of arm's length showing, that can be enough to win the day. Another area where it comes into play is for primarily nonprofit hospitals, but generally any organization that its primary exempt purpose is to promote health. The IRS has this community benefit standard that requires a majority of community directors. And the third area where it's really become important, which we'll get into later, is it's become a focus of the new IRS 990. All 990s are public documents. I mean, you could give me the name of an organization, I could go on the internet and get your 990 for the last 3 years in 5 minutes. So anyone can look at your tax return, your 990, and by reporting what your governance practices are, you're not only telling the IRS, but you're telling the rest of the world how you run. Okay, let's take a look at the community benefit standard, which was first laid out by the IRS in 1969 by a key revenue ruling, and it really is the IRS's attempt to distinguish between for-profit and not-for-profit hospitals is really what it's originally directed to. And one of the factors in which the IRS says will allow you to be exempt and not-for-profit is if you have a majority of your directors as a community board. The idea is we want for a tax exempt hospital to be tax exempt, the IRS wants them to be